News Radio 700 WLW.
Effectively known as America's attorney, someone who has walked into courtrooms all over America, made judges stand in reverence, and opposing attorneys cower in fear. He's a good guest of this program. We like him a lot. Jeremy Rosenthal, how are you on this glorious day?
Ken, and yes, I've never lost a motion to continue in my life. Those all go on the websites as big. It's an acquittal right there for the moment, even if it's just temporary. But yes, doing great. How are you?
In the old Superman TV show back in the 50s, there was always some sort of criminal that looked at Superman and said, I want to make a deal. And Superman says, I don't make deals. That's exactly what you do, isn't it?
That's right. I'm going to tell you what we're going to do, and I'm going to tell you how you're going to feel about it. That's how we're going to do this. That's what's happening here. Yes, you got that right.
It seemed like ever since Donald Trump took office and this lawfare began, you and I have been talking about stay in your lane orders that needed to come down from the Supreme Court to these district judges who thought they ruled the world. And finally, the Supreme Court rules on Friday 6-3 exactly that. It was a case that involved birthright citizenship. That hasn't been resolved. But what has been resolved is that these district court judges kind of got slapped down a little bit, didn't they?
It's a definitely a lot more of a limitation than we've been used to seeing. A district court judge, a federal district court judge, can resolve the controversy of the parties in front of them, and really not a lot more. And that's essentially what the Supreme Court ruled today. And so you're not going to see nationwide injunctions anymore, in all likelihood, from just individual district judges.
I thought if it ever came to this, it would be a 5-4 vote. I didn't give John Roberts much credit for siding on this side of the law. He seemed to be one of those guys that was a backslapper, and that he put a lot of these judges in place, or in some way, shape, or form mentored them. So Roberts' vote on this, siding with the majority, kind of surprised me a little bit. Did it surprise you?
Maybe a touch. It maybe a touch, I think, is the short answer. This was a very, very long opinion, and it is like most Supreme Court opinions. There's a lot of mud and there's a lot of murk, and you got to really kind of slug your way through it. Really, what it sort of comes down to is how the Supreme Court, they interpret different things. Sometimes they're interpreting the Constitution. Here, they were interpreting a statute, and essentially what they're saying is that it's Congress that has the ability to give a federal district judge the wherewithal to enjoin the entire nation. So, because we don't think that this judicial act from 1798 does that, we're going to limit that. So it's not necessarily unconstitutional for a federal district judge to enjoin an administration across the board. But basically the statute, they just said, look, that statute, you're just taking it just a little too far. And I think too, you've got to look at the recent history over the last 20 years. You've seen as Congress becomes more and more gridlocked and more deadlocked, you've just seen a lot more legislation, if you will, or a lot more governing through executive order, which is why you're seeing so many more of these executive orders that get thrown out and then they get blocked completely. Barack Obama had it happen to him. Joe Biden has had it happen to him. Donald Trump has certainly had it happen to him. And now it gives the executive branch far more leverage than they've had before.
Yeah, I would almost enhance that by saying that this is totally on Congress. I mean, if judges on the district level are quick to jump up and rule, Congress, particularly the House, but certainly the Senate, are very slow to the jump and oftentimes get bogged down in minutia that prevent the will of the people being governed into law. And I would say that as much as this is a 6-3 Supreme Court decision, I think its roots are in just the absolute inability to get anything done inside the House and the Senate. Would you agree?
Oh, absolutely. Absolutely. Look, if you think about it like this, if we're going to kind of talk Cincinnati Bearcat basketball, right, against the Red Raiders, who are the best, in the Big 12, you drive to Thank you.
Right.
You passed a sobriety test before this interview, but go right ahead.
You drive to the hoop enough, you're going to get a bunch of foul calls. That's how this works. And when you govern by executive order, you're going to get sued. It just will happen. Now, I mean, there's executive orders and there's executive orders, right? I don't know that anybody's sued over the Gulf of America. But the birthright citizenship one is certainly, if nothing else, not extraordinarily controversial. You knew that was going to draw a lawsuit. I think it drew multiple lawsuits, and now so you know that's going to be the impact of it, right? The more you drive the lane, the more fouls you're going to have. So the more executive orders you have, the more federal judges that are going to be essentially ruling on these things. And when we go back even a step further, we have these executive orders because Congress can't get along. So that's why you see as many executive orders as you do. And that's why that's going back over the past 15, 20 years.
What effect will this have long term, do you think, on how the president, not just this one, but any future president will rule? This president was blocked so many times. I think it's an overwhelming number. It's in excess of 90% of the judges that have blocked what he wants to do were liberal judges or judges appointed by Democrat presidents. But yet you could always flip the script, right? 10, 15, 20 years from now, it might just be the opposite. It might be a Democrat president that would have been blocked by some of these judges. Do you honestly think that this will keep these district court judges in their lane, or will they be salivating to try and get some decision they make in front of the Supreme Court eventually?
That's a wonderful question. I think when you look back at this Supreme Court in 30 or 40 or 50 years, I think that's what you're going to see. Their legacy is their relationship with the executive branch. Between this opinion and last year's opinion with Trump versus the United States, you see a really broad expansion of the executive. And yes, be careful what you wish for, because in 10 years, you may kind of regret that the executive has this kind of authority. You don't know who's going to be in the White House. And think about it like this. And and I've been challenging people with this all year on this exact same topic. Let's say the chief executive decided that all firearms were contraband and I'm going to go collect those. Well, a federal judge would enjoin that and say, stop, you can't do that. But now what you're saying is that maybe the NRA could do that and any members of the NRA could do that. But then do individuals have to go start asserting their rights to do this? So when you have a very powerful executive, you just have to be, this is what you're getting. And so you have to be, we just have to sort of understand that these are kind of the new boundaries, and what may be really wonderful or what people may think are wonderful today may not be the case in 5 or 10 years. Now, you may also get Congress who jumps in here and says, okay, we are going to redefine the boundaries of where judges can enjoin. In fact, you probably will. If they can agree long enough to go to the bathroom or something like that, if they can make a vote like that. But this is a definitely an invitation to Congress to come in and clean this up and say, okay, here's the boundaries, here's what's onside, here's what's offside, here's what a federal judge can block, here's what they can't block. It's an invitation for that to happen, and that's the real thing I think we all ought to be looking for here.
Yeah, I'd give Texas Tech a better chance of beating the University of Cincinnati on the hardwood than I would of that happening in Congress. One of the things that I loved about this yesterday, I love great theater. I really love great theater. And it was the fight inside the fight. You got Jackson writing, the court's decision to permit the executive to violate the Constitution with respect to anyone who is not yet sued is an existential threat to the rule of law. And she says the people that can lawyer up will lawyer up, and those that can't. And then you come right back, you got Amy Coney Barrett just basically dismissing what her fellow Supreme Court justice said. She says, we will not dwell on, in capital letters, Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent. Now, how do you think that's going to go in the Supreme Court Justice Lounge in the coming weeks?
They're going to laugh over it, over wine, and enjoy their great dental insurance. That's how they're going to do this.
You really think so? That won't be their.
Yeah.
You really?
I don't know. Yeah, it's theater. No, I think you've hit the nail on the head. It's certainly theater. But these guys they're all backslappers, and they're all, ha ha ha, my colleagues this and my colleagues that. And Justice Scalia and Ruth Bader Ginsburg, those guys were besties, and they wrote books together, and probably that's how it ought to be. And look, they have their dance offs are different than our dance offs, and they kick these opinions back and forth down the hallway. And yeah, maybe they're like you and me, and maybe some days Amy Coney Barrett is, she's going and parking and getting there in the morning, and she's looking to see who else's cars in the parking lot, and we're gonna take the long way to the bathroom down the hallway. Maybe it is like that. I don't know.
Yeah, I don't. But I mean, that's something straight out of any county's common pleas courtroom. I don't recall that kind of thing ever being said, where one justice calls out the other for being basically a nitwit. And maybe it's happened. I don't know. I've heard other justices and opinions mention the other justice by name. But I mean, that even if it was just one of those things where, you're my buddy, but I'm going to say anything I want about you, it was kind of dramatic, I thought.
Yeah, normally when they do that, they say the dissent says this, and the dissent is, or the majority is mistaken in that, and there's some pretty hardcore language. But look, you also have to understand too, these are keyboard warriors, and that's what appellate lawyers do. That's what appellate judges are. They kind of they sit there, and we've got appellate lawyers in our law firm, and you can tell because they're always in the office drinking everybody else's coffee, and they're kind of laughing to themselves and snickering about their funny jokes that they make in their briefs. And it's like, let's do this in front of a jury, but tough guy. Let's go and let's take this to the streets. Yeah.
We're chatting with our good buddy Jeremy Rosenthal, America's lawyer, who coined the phrase, every time a lawyer gets paid, an angel gets his wings. This is not the end of any of this. I think we both agree on that. But the Supreme Court has basically dusted its hands, and it's done for the summer. What business is left for them? They've got several things still on their plate when they come back in October, right?
Right. So they take kind of these bigger, harder questions it's what's called a court of discretionary review, meaning that they don't have to necessarily take your case. But the slower cases that the world's not going to end on, they usually put in this sort of a term, but they can still deal with emergency situations, writs, death penalty stuff that kind of, they're going to execute this guy in North Dakota. We better step in or not step in. And you're always going to get that kind of stuff so they're never completely on vacation. But again, they got the good dental plan up there, is what I've heard. So
well, President Trump seems to think the traffic jam is over and the fast lane is open, and it sounds like from what he's been talking about since this decision was handed down is that, you know what, here we go, buckle up, boys, we're going to do 90, and we'll see if that exactly happens. It never really looks, well, I shouldn't say that, it never really becomes what it looks, does it?
No, it never does. No, that's a good way to put it. So we'll see if what he's got planned. You would think that he's rolled out a good majority of what he's already kind of had done. Maybe he tries to repackage some of it. Maybe he's got some buns in the oven that we don't know about, and maybe we'll get some. But I wouldn't be surprised to see some new executive orders in the next couple of weeks. That's for sure.
He's had a hell of a week. Jeremy, you stay well, stay cool, and we'll visit down the road because, as I always say, yours is a voice we need to hear. So please stay well, and until next time, thank you for this time.
Thanks, Ken. Have a good weekend.
Bet. America's lawyer, Jeremy Rosenthal.